But my daughter doesn't have that second chance to enjoy her senior year either, after all this stuff started up in the summer of 2018. She doesn't get a second chance. My daughter wasn't physically involved with him. It was pictures and grooming. There were some other girls that just didn't want to get involved. So I can't say that this is just an isolated event. I'm not the father of the one that he had sex with. And I talk to him occasionally, and they don't get a second chance.
And we are about to watch the parole hearing for a former high school basketball coach. Why, he was indicted on over 7 counts of indecent behavior with the juvenile and carnal knowledge of a juvenile. As a matter of fact, this 38-year-old man at the time of the crime, married with 5 children, he took his 16-year-old victim into his house and did it with him in his daughter's bedroom on his daughter's bed. Now, here he is showing up to his parole hearing. By the way, he only received a 5-year sentence for this crime with multiple victims, yet somehow the DA, wow, they feel that putting someone in charge of coaching and mentoring our children in school, that 5 years is enough of a sentence. But as I'm sure you are accustomed to by now, we're going to hear from his support. And the words that his support say, the words that they use, very educated, a doctor, as a matter of fact, will make statements that I think will simply enrage you. Now, I think that's enough said. I'll unpack it with more details from the appeal at the end.
Edward Garriet, 753521.
Mr. Garriet, you're before this panel today as a first felony offender, serving a 5-year sentence for carnal knowledge and indecent behavior with juveniles. You have a parole eligibility date, 10/7/2024. You're not eligible for good time release, and you have a full-time date of January 7th, 2026. Does that sound correct to your understanding?
Yes, ma'am.
We do have several members in support here. We have Dr. and I don't want to say the last name incorrectly. Would you introduce yourself, Dr. Mike?
I'm Dr. Mike Fulgens.
Okay. Family friend, you have Edward Garriet Jr., your father, and Gerald Davis, a family friend. You do have a member in opposition, and they will be able to speak last. Before we get started hearing from those individuals, I would like to ask you, sir, could you let us know, tell this panel why you find yourself incarcerated and why we should consider early release?
I find myself incarcerated because I made a very bad decision that it hurt me, it hurt people involved, the victim, family, my family and friends, and it was a very bad decision on my part that I'm very hurt by. And I ask for forgiveness from everyone that I'm involved with, also from God as well.
And why should we consider you for early release?
Because as my time here, I realized that the decision I made put me here, and it was my decision that I made. And while my time here, I took some time to reflect and think on the things that I did. And I took time to keep myself involved in a facility and doing things so I can help other people, so I can better myself. When I am released, I'll be ready for society and also be able to still help people when I get out. I learned what I learned from being incarcerated.
At this time, we will hear from your father first, Edward Garriet Jr. Would you like to make a statement on your son's behalf? Mr.
Yes,
Garriet?
ma'am. Yes, ma'am. I just miss my son, and he's a great son. He always made me and his mother proud. He he never failed us before. And he always helped other people. I played basketball and I didn't get to really go to college, but my dream was for him to do the same and make it to college, and he did. He played, he graduated, and after that he started teaching, and he and I, we started helping kids. And I'm just proud of what he had accomplished and to try to get that back in focus. I could really use him home because I'm having issues at home, myself and my wife, and he's needed. And thank you.
Thank you for joining. We also have Dr. Mike.
Thank you. And thank you for your service. I appreciate everybody serving on the board. I've served on the State Bar of Texas Advertising Review Committee 3 terms, been the president of the Diocesan Catholic School Board. My father was the district attorney for juvenile court in Lake Charles, Louisiana for Calcasieu Parish, and often brought me as a teenager. And he always said, we're here to help kids get a better life, and if appropriate, a second chance. And I appreciate that. I've also served 9 years on the Crime Stoppers board here in Beaumont. I taught high school chemistry. Doobie was a teacher and a coach. I coached kids, boys and girls 6 to 17, my father and daughter. I was a principal of the State Gifted Children's Program. So I know the challenges and the temptations that you face as a young teacher. I coach kids, boys and girls 6 to 17. As a teacher, doesn't excuse anything. And my heart goes out to the victims. I do want to give you a flavor for Doobie from his coaches that I talked to, George Price and Dave Simmons at McNeese State. Doobie always had a smile, great teammate, never got a technical foul, never was in a fight in all the college games he was in, and he was all conference in the Southland Conference. He worked as an assistant coach at McNeese after he graduated. He took a higher paying job in high school in Westlake, but the respect for his coaches for him and how he carried himself, how he worked with teammates, how he taught when he was a teacher at McNeese State will be there with George Price and Dave Simmons. I saw that when I sponsored and helped out at our low-income YMCA in Beaumont, where I met Mr. Garrett. And Doobie would volunteer there and was very helpful. Mr. Garrett and I have stayed in touch for years. His wife, Cora, is not in good health. Mr. Garrett and I talk. Doobie's daughter graduated from McNeese, was on the dance team. And I think he could be a great asset to society if given a second chance. But I do not know what has transpired other than hearing from Mr. Garrett since he was incarcerated. And so that part you have to weigh in this. But I'm giving you some context to the Doobie Garrett I knew and others knew during that time frame. Thank you so much.
Thank you. And now we have also Gerald Davis, family friend. I believe you're on mute.
Okay, let me see. I'm trying to see, work this technology to unmute. Oh, can y'all hear me now? Hello, how y'all doing? I'm actually, my name is Bishop G.W. Davis. I live right next door to Doobie and his mom. And I was his dad's mom's pastor. She passed, and I was his mom's pastor before they passed. And I've been living next door to him for about over 15 years now. And I've observed Doobie for myself. And I don't know the circumstance surrounding or whatever happened with his case, but personally, myself, from being involved with this family, observing Doobie with his daughters that he raised, not only his daughter and his son, but his stepdaughters. he raised them also of his wife, that he raised those girls. And Jordan that Mr. Garrett talked about, she graduated from college. His other daughter, she's married. She's living over in Orange. So I don't know the particulars, but I do know that Doobie is a great guy, and I believe in my heart that we all have stumbled somewhere along in life. But Doobie's never been in trouble in a day in his life. He has no record or anything for no offenses. So I plead with the pardon board to have some compassion, to give him another chance to come out and revamp his life. He's coached many of girls and stuff like that. And I'm not negating what happened to the young lady. I can't speak about that, which I don't know, but I know she has some hurt. Also, we just asking for forgiveness, we asking for mercy, and we asking for compassion, not only for him, but also concerning the young lady that went through this experience. And thank y'all, and God bless.
This time we'd like to hear from Mr. Ken Flew, the victim's father.
How are y'all today? Just sitting here listening to what's been said. I understand that Doobie comes from a caring family. Daughters are doing well, kids are doing well. But there's some things that stood out. Yes, I believe that everyone deserves a second chance. I do. But my daughter doesn't have that second chance to enjoy her senior year either, after all this stuff started up in the summer of 2018. She doesn't get a second chance. My daughter wasn't physically involved with him. It was pictures and grooming. There were some other girls that just didn't want to get involved, so I can't say that this is just an isolated event. I'm not the father of the one that he had sex with, and I talk to him occasionally, and they don't get a second chance. Just 8 days ago, Governor Landry was quoted in saying that, let me get his quote right here. Said Louisiana will always prioritize victims over criminals, law and order over lawlessness, and justice over the status quo. And the way I see this is just status quo. These offenses started pre-2018, and he didn't get accused until 2019. Whatever happened in the past, I got my own opinion about that, but I won't go into it. Court was put off until like 2021. Even then, the judge was given that the lawyers agreed to 14 months. And we'd already lived through over 2.5 years of dealing with this, and he was gonna get 14 months. Judge came back a few months later and said 5 years. This is way less than what should have been given to him anyway. So he's get extra time out of prison. He gets a sweet deal, gets still a pretty sweet deal of 5 years, which could have been a lot longer. And now we're going to cut it down even further. This is just status quo for this situation. I understand he's going to get out someday, and that's fine. He doesn't need to be in there beyond what he's been sentenced. That's out of my hands. But my daughter, we couldn't even go on vacation and enjoy it right after she graduated, because we went to Europe and she couldn't even be around other guys that were on the bus and stuff. It was ugly. It was really ugly. So there's been some problems in that. So he can move on, but a lot of these victims are having problems with it. And I understand that he has support, and that's wonderful. I hope you do get with those people and things do get better, but I mean, we're still dealing with this as a family, and as, you know, how are we going to go on from here? What's it going to look like? So I understand all these things. I can and will forgive him. I mean, it doesn't mean I have to have anything to do with him, but I would like for the board to consider, fulfilling what was sentenced to him instead of just status quo, cutting back and letting things go. And I appreciate it. Thank you very much.
Thank you for
Thank you.
joining us. Mr. Flew alluded to, you did have 6 counts against you, Mr. Garriet. At this time, we're going to allow Ms. Renatza to begin our questioning.
Thank you. And thank you, Mr. Flew, for your remarks and your comments. We do appreciate you participating today, and all of you who have participated. Mr. Garriet, and I agree with your father that you have achieved some accomplishments, but in your statement, when you first got started, you said you made a bad decision. And you've suffered, and others have suffered, but it was more than one bad decision. Would you say? Would you agree?
Yes, ma'am.
Because it wasn't just one victim. I mean, we have the record, and there were multiple victims. And what's concerning to me is, you in your teaching capacity, you betrayed the trust of your community and all the students. Now, and I do appreciate what Dr. Fulgens has said and provided context for us, and your upbringing and your career as a teacher. So let me ask you, but he did defer to us on what you've done since you've been in prison. So, and I will agree with Mr. Flew. I think you got a pretty sweet deal. Now, I know you're at Catahoula, right? Is that where you're at? Is that where you're housed?
Yes, ma'am.
And I don't know what kind of programs they have there, but the program that is important to me and you is sex offender treatment. Have you been afforded the opportunity to for that treatment program?
Oh, ma'am, I've been in Caterpillar my entire
The whole
incarceration.
time?
Yes, ma'am.
Okay. What about victim awareness? Is that program available there?
No, ma'am. The only program I've been involved in is Life Healing Choices.
Okay.
And I got my OSHA's training, my OSHA safety card, and my forklift certification. And I've also been a trustee for going on 2 years now. I'm right now in commissary.
Good. I'm going to be honest with you. I don't, lacking, and also pre-release. I don't see there where you got the 100 hours pre-release, and that is a requirement of law now. Lacking the sex offender treatment and the programs that are required by law, I'm not in a position to grant you any relief today. I can make a recommendation that you be moved to a facility that offers the sex offender treatment. I think it's important for you to dig deep and figure all that out, why this happened, before you release. The full term date, Mr. Flew, his release date will be January 7, 2026. That's his full term date. Mr. Garriet will have some challenges with the requirements for sex offender registration and all the things that go along with that. Anyway, Ms. Ledoux, I'm going to just offer my vote at this time and then defer to you all. My vote today is going to be denied because he lacks the opposition. Of course, it's been expressed, but he lacks the programs that are required.
Mr. Freeman?
My vote is the same. He needs a sex offender program plus victim and law enforcement opposition.
And I also vote to deny parole based on the abuse of power over minors and lack of training in sex offender reentry. So today, by unanimous vote, your parole has been denied. Wish you well. And it's 11:09 and we're signing off there.
Thank you.
And there you have it, a denial. But, it never gets old. We have to hear from these supporters that are just like dangerous, in my opinion. It's crazy. It really was crazy for me to listen to that doctor who you find out has these positions of power that were to protect our children, where he was a teacher himself, where he was a coach himself, where he was on the board of Crime Stoppers, where his father, I mean, all of these roles being involved in protecting communities of children. And he gets up here and he gives a kind of speech about how the guy had no technical fouls in college and he should get out. Are you nuts? Who are these people? And but they never fail to amaze me by their complete, I don't know what it is. I'm going to say stupidity, but it's not that. It's like they're sick. I know the challenges and temptations of teaching kids from 6 to 16 years old. What? I mean, I don't want to hear a teacher say those words, temptations. I'm sending my kids to a school. If you are having temptations about having sex with my daughter, then you don't belong as a teacher, sir. Why is that even something that would be, what are you saying? And then he shows up to his parole hearing and he outright lies. He says one incident, like as if it's one victim, as if it was one, and we have the father from just another victim show up and speak. I found 5 indictments, I should say Lady Holly found 5 indictments, and Miss Renata, I think, said that there were 6. Neither here nor there. 5's enough. We'll go over the appeal because he appealed. He thought that 5 years was too tough of a sentence. And again, it's not like this happened years ago when this happened in 2019. He got sentenced. How is it possible that we are allowing coaches to literally have sex with a 16-year-old student to get away with a 5-year sentence? And it's not sex. That's what they call SA. You can't consent. But they're put in charge to protect us, to protect it doesn't just, it's not just the single act like the parole board alluded to. It's just mind-blowing because you're eroding trust in society. You're destroying trust in our teachers and our coaches. The ripple effect, it's limitless. And we keep seeing this happening over and over and over again. How could a judge hand down such a light sentence with parole eligibility after serving a couple years? And I know I'm not the only one enraged by this. You know, I know that most of us watching this feel sick, but still it's happening over and over and over again. Judges and DAs. And does the DA show up? No. Can't take the time. And this was a news story. This did make the news. Thank you, Lady Holly, for pulling it. Let me share with you actually this news story, what the two-faced DAs say, because they are two-faced. And then we'll go over the appeal. They are two-faced. Let's see what they do here. A former Westlake High School basketball coach has been sentenced to prison for sexual involvement with students. I love it. They call it sexual involvement. How do they pick these words? Edward was sentenced by Judge Ritchie to 5 years in prison on 2 counts. Those counts include carnal knowledge of a juvenile, 10 years in prison with 5 years suspended, plus 5 years probation, and indecent behavior with the juvenile. Oh yeah, let's add insult to injury, by the way. He only needs to register for 15 years. No lifetime registry. 7 years in prison, 2 years suspended, plus 5 years probation to be served all concurrently. All of this comes out to 5 years. Assistant District Attorney Denise Parole prosecuted the case for the Calhoun Parish District Attorney's Office and Westlake Police Department. I hope the victims find comfort in knowing that they saved other teenagers from being victimized by him, Parole says. I hope they realize how truly strong they are. This is the DA that agrees to this deal. I hope the victims have comfort in knowing that they saved other teenagers. DA, you gave him 5 years and you only make him register for 15. Yeah, you're right. The victims were courageous in saving other victims. But what about you? Why don't you do your job? A native Valmont, Texas, Garrett had worked in the Calhoun Parish board since 2001, serving as special education teacher and coach. He was a special education teacher as well and coach. This is scary. I mean, he was there his whole life. It's just scary. He had served as the coach for the Westlake girls indoor and outdoor track and field teams, as well as an assistant coach of the girls basketball team. He was also on the Rams football coaching staff during his tenure at the high school. I'm guessing that's the high school football team. When Garrett was indicted in 2018, the district attorney's office said the then allegations revolved around 4 students. He is also a former State University basketball player and assistant coach. He played for the Cowboys in 2001 to 2005, appearing in 108 games. Starting in 60, he was named the team's most valuable player. And as we all know, he never had a technical or a fight. That clearly, for anyone who doesn't have it, he's a doctor, right? So obviously we don't understand. Only the doctors understand that people who do this against children, they never have. I mean, clearly, if they've never had a technical foul on them in 4 years, that means that oh wait, actually, sorry, we all know that these chomos, right? They don't have write-ups. They don't have technical fouls. It is by nature first-time felony offenders, but apparently the doctor doesn't know that yet. He's too, even though you would think that with his background, being with his father, being in the DA, and all of the boards he's been on, that he would know that by now, know it enough not to make that a statement in a parole hearing. But we shouldn't question the doctor. He clearly is much more knowledgeable about all of this than we are. So let's go to the appeal. The supporters make me sick. What they say, it's always the butterflies and the turtles, and then we hear from the victims that actually, in very few amount of words and no fanfare, often state the facts. On July 25th, and he spoke well. Dad spoke great. I am so happy he was there because we know the DA couldn't care less to be there. With 1 count felony criminal knowledge of juvenile under and 5 counts of indecent behavior. Really, what that dad did was amazing. On June 2nd, 2020, the defendant withdrew his previous plea of not guilty and entered a plea of guilty to 1 count criminal knowledge of juvenile. He was going to go to court, this guy, right? And indecent behavior with the juvenile as part of his plea agreement. Like he literally essayed a 16-year-old in his daughter's bed. And that's what they give him. I mean, think about the lives he wrecked with his children and his wife. Like they couldn't go back to, imagine going back to school with your dad being that guy. I mean, the ripple effect is so, he's making these decisions. Someone who does this, it's not normal. These are predators. This is dangerous. What are you even saying? He doesn't have the impulse control. Like, it's so nuts to me. This is nuts. I keep getting more enraged just thinking about this. 5 years? See this? He only needs to register for 15 years. Because we all know that he won't be a risk to children once he's 60 years old. We all know that that urge goes away. September, I mean, he had daughters the same age. Again, I'm going to go on a tangent. You see this stuff in predator captures all the time. They have daughters the same. Like, doesn't that tell you there's so much Oh my God. All right. On September 30th, 2022, the trial court held a hearing to re-sentence the defendant. Trial court reinstated the previous imposed sentences. However, trial court amended blah, blah, blah. Okay, let's go to the facts. The state set forth the following factual basis of the defendant's guilty plea hearing. As to carnal knowledge of juvenile honor between August 2018 December 31st, 2018, the defendant committed carnal knowledge of juvenile, which is full-on SA, right? Whose date of birth is 2002. And that's how you get it 18 in 2002. That's 16 years old. The victim was a student at the same school where the defendant was a teacher and a coach. The victim is a neighbor of the defendant and a friend of his children. Like what he did to his own children just by doing this is enough to get a 5-year sentence, in my opinion. He was trusted friend of the victim's father, and he was a trusted friend of the victim's father. This is just full on sick. The defendant would sometimes give the victim a ride to school. The victim, I mean, full on grooming. This is like full blown sheep in wolf's clothing grooming. Except he's a coach. You need to have stronger punishments. On April 17, 2019, and she disclosed that on at least one occasion, he engaged in carnal knowledge with her when she was older than 13 but less than 17. She went to the defendant's house. They engaged in sexual intercourse in his daughter's bedroom. The victim disclosed this to her sister and to other friends at school. The victim is not the spouse of the offender, and the age difference between the defendant and the victim is 4 years or greater. I love how they have to add that in there. Wow, things. As the indecent behavior with the juvenile on or between August 1st, 2018, December 31st, 2018, the defendant, Edward, committed indecent behavior with juvenile with the intention of arousing, gratifying, transmitting, and lascivious images, specifically images of his genitals. He was sending his genitals to other victims, whose date of birth was August 5th, 2002, a person whom the defendant reasonably believed to be under the age of 17. No kidding. They're his freaking students. And reasonably, she was a student at the same school wherein he taught and was a coach. The victim's cell phone, as well as the defendant's cell phone, shows communication wherein the defendant and the victim shows this type of communication between the defendant and the victim. I mean, he could have gotten more time simply for transmitting, right, images to, you would think he could get more time for that. And if she sent him images, you would get more time just for that. You have the forensic evidence to lock him up for so long. That's how pathetic and weak these DAs and judges are. The defendant commented how he wanted to have a threesome with JS and another victim. 3 other victims include other students CC, LF, and SV. Okay. And basically, like in his appeal, he said, what did he say? Pencil to impact others. Acknowledgement of the victim's ability due to her age, lack of self-esteem, and lifelong impact the defendant's action may have for the victim. The state concludes that asserting the trial court, the defendant sentence part. Remember, he didn't go to trial. They gave him a plea deal. And his appeal is it was too excessive. Like, are you kidding me? They gave you a gift, and then you appeal it. It's too excessive. Let's see what this says here. At the original sentence hearing, the state defense counsel recommends the trial court suspend all but 16 months of the defendant's sentence in accordance with the similar situated. Following the recommendation, defense argued the defendant did not have prior criminal history and was worth more than the worst things he had ever done, and requested the judge shut up. Thereafter, the state argued the defendant was a person of whom the victims and victims' families trusted, but ended up being a pedophile. Thank you that robbed the victims of their innocence and confidence. When imposing the sentence, the trial judge explained the following. Bottom line is, if I didn't have the recommendations that I have, your sentence would be much worse than that of what it's about to be. What recommendations? We can get inside the head of this clown judge right now. I guess what I'm saying to you, and so I'm being as the sentence I'm about to impose is about as generous as I can be in the light of all the circumstances, and still it's the best I can do and show respect to these victims and their families, and also give consideration for this balance that I need to be able to have in this matter. So, as I said, I've already imposed the 10-year and the 7-year, and I'm going to suspend each of those, all but 5. So you have 5 years to serve, and then you'll have 5 years of probation with all the conditions that I'll impose a while ago. And I'm telling you that in the light of various victims that are involved here, and I think that and the damage that's been caused to these victims, I think that's really, to me, I'm reading word for word what the judge said, which kind of is, the only thing that's close to justice in light of all the circumstances in this case. When I hear, and I'll give you credit for any time served, yeah, it'll be concurrent on each count with credit for any time served from the date of your arrest on charges, and I will notify you. And by the way, I do have to say, looking at the article 894, the sentencing guidelines, the lesser sentence would be depreciate your seriousness of the defendant's crime. Look under B. This judge sounds as literate and I guess as I'd expect. This is ridiculous. Are you kidding me? You're a judge, But under the grounds of consideration, aggravating and mitigating or aggravating factors, look at what? Consideration, aggravating and mitigating, or the mitigating or aggravating factors, or the defendant knew or should have known, but the victims of the offense was particularly vulnerable. I don't know, whatever. Truth is, when you whatever, the court. So yeah, I would say, yeah, that's a mitigating factor. And like I said, I would consider also, the others, those letters of support, mitigation, because, I do, like I said, I do think those were beneficial to you, Mr. Garrett. Whether you believe it or not, those were beneficial to you because you may not, like I said, you may not believe this, but I can tell you it could have easily been higher. This sentence could have easily been higher. But I know as much as possible. I tried to honor the recommendations of the state and the defense, but in this case, I felt like it was something that, that 16 months there was just not. So I just realized this now. The state only wanted to give him 16 months. The state and his defense agreed on 16 months. They were going to give him 1 year and 2 months. And the judge actually said, no, I'm going to give you 5 years. Wow. 16 months. There was just no way that could possibly be adequate for what was done here. And I know the family may be feeling that 5 years isn't adequate. No, it's not, Judge. But, I'm trying to balance all the considerations here, and I hope everybody can. I hope the families can respect that, and I hope everybody can respect that, but they probably like to see 10 to 15 or 10 or whatever. But I'm trying to balance all the considerations here. Judge, really, what are you considering? A pathetic DA trying to agree on 16 months? And I hope, Mr. Garrett, when you finish serving your time, or while you're serving your time, you do some soul searching, and instead of feeling sorry for yourself, that you actually start thinking about maybe what you can do to actually, do something for people and help other people to make amends for your crime. Obviously, there's nothing that you can do for all these victims, but maybe for other victims in this case, all right. I don't know. I feel like I lost 10 remaining brain cells by reading that. That's a judge, ladies and gentlemen. As to nature of the background, the defendant was a 37-year-old spouse and father of 5. Defendant had no prior criminal history. Whatever. There you have it. We've been here doing a 20-minute unpacking for a 20-minute parole hearing, and I'm sorry about that. But sometimes I feel like this context is important. Thank you, Lady Holly, for doing the research on this case and highlighting it as a case that we should cover, because these are the cases that we need to cover. And with that, I'll let you go.
But my daughter doesn't have that second chance to enjoy her senior year either. After all this stuff started up in the summer of 2018, she doesn't get a second chance. My daughter wasn't physically involved with him. It was pictures and grooming. There were some other girls that just didn't want to get involved. So I can't say that this is just an isolated event. I'm not the father of the one that he had sex with. And I talk to him occasionally, and they don't get a second chance.